Welcome to Just Verdicts with your host, Brendan Lupetin, a podcast dedicated to the pursuit of just verdicts for just cases. Join us for in-depth interviews and discussions of cutting-edge trial strategies that will give you the keys to conquering the courtroom. Produced and powered by LawPods.
On this episode, I talk with Scott Perlmuter, a partner and trial attorney with Tittle and Perlmuter in Cleveland, Ohio. Scott and attorney Katie Harris recently got a $1.3 million all non-economic damages verdict in a slip and fall in Cleveland. And we talked with Scott about the secret sauce and the factors that played into such a great result. Scott talks about the importance, in particular in this case, with the type of defendants he was dealing with in being off code and being very conscious in the way that he approached his cross exams. Scott talks about how focus groups helped he and Katie figure out how best to frame and present the evidence in the case. And Scott shares a number of other takeaways from his approach to opening his influences in trial practice that will help you in preparing and getting a great outcome in your next premises case if you've got one coming up. So I think you'll enjoy this interview with Scott Perlmuter. All right, welcome to Just Verdicts, which is the first time I'm saying that on the rebrand because I determined that trial and medical error was too much of a mouthful to say and not as snazzy. So I'm completely rebranding this highly listened to podcast to Just Verdicts. And I'm excited to have as our first guest under the new banner, Scott Perlmuter from Tittle and Perlmuter in Cleveland, Ohio. Scott, thanks for joining me today, man.
Thanks so much for having me. I didn't even know about the rebrand.
Nobody did.
I got to totally rejigger my content here.
Yeah, I apologize for throwing that curveball at you right off the bat. I know all of your lines were oriented towards trial and medical error, and just saying that over and over again. So
Exactly.
This will hopefully make it a little more simplified. But no, I mean, the whole purpose of the pod is to talk with trial lawyers like yourself who obtain great verdicts to find out how they did it. What were the secret ingredients and the magic behind an awesome verdict. And you got a terrific premises slip and fall verdict of $1.3 million recently with Katie Harris from your office as well. And I saw it on LinkedIn and, jumped right out to me because, I think I just was born to be a personal injury lawyer because unlike most people, I think my favorite type of case to try is a slip and fall. There's just something about them I love. So when I saw that you got a great verdict on this case, I really was excited to talk to you. But before we dive into the case, Scott, could you, tell us a little bit about yourself, your background. I know you're from, lifelong, I think, Clevelander, right?
Yeah, most of my life. I lived here, since I was like in middle school on. And maybe I'm crazy for doing that, but I love Cleveland.
Well, tell me about, growing up and, did you go to school in Ohio, and then, how did you wind up in the law? Because as we were talking, we both shared the fact, well, your father-in-law's, I don't know why I keep wanting to say your dad is the doctor, but anyway, how did you wind up in law and in the particular area that, your firm practices now?
Yeah, so I think probably the biggest factor that led me into practicing law was the fact that my father was an attorney, and my father was, as many people would say, my best friend and person I looked up to most in life. And I had such immense respect for his intelligence and integrity and what have you. And so I think that that's probably the thing that led me most into law. However, he was not a litigator. And he actually, he was an expert in ERISA. We're going to talk about, I guess to a degree that I have to do some ERISA work myself. He was working for the IRS as an attorney when ERISA was passed in 1974. And so he then became one of the go-to guys in DC and then in New York and then in Cleveland in ERISA. And so that was not anything that was particularly interesting to me when I went to law school. So I went away for college to the University of Wisconsin, Badger, and then came back here to go to Case Law School. And I always wanted to be a litigator. I was always really interested in like civil rights work. That's actually what I did for a little while when I first graduated from law school. And I didn't really know that I wanted to do injury work when I was in law school. But then once I got into what I would say is, pretty related field, doing civil rights work, that led me to injury work. I worked on a case with a firm that did all injury malpractice work, and then got a job there and spent the next 10 years doing all injury malpractice work. And then, like I said, about 10 years into my career, I had one ERISA case cross my desk, and I talked to my dad about it. It had to do with a guy not getting his pension. And, ultimately I felt like this case, ERISA is like such a scary word, even for lawyers who practice in the employment realm, or lawyers who deal with employee benefits can be scared to litigate in that field. But like, I talked to my dad about it, felt like this seems like a case that I could do. It's really just kind of trust law. And so I started doing that one. And then I also do class wage and hour cases. So I also had, like, around the same time, one class case where I was asked to co-counsel with another lawyer. And that led into, so that was probably about 6 or 7, 8 years ago. That led into developing this additional practice area where I do, like, mostly class, sometimes one-off employee benefits or wage and hour class action cases. So I would say my practice now is divided. It's mostly still injury and malpractice cases, and I love trying cases, and really don't get to try those employment class cases at all, although I might have one this year, but that would be my first trial ever, because no one tries those cases. But, then I have, like 30-40% of my work is this class wage and hour employee benefit stuff.
As you look back on your, growing up and going to school, and obviously your dad had a really positive influence on you, is there, some particular, book you read or movie you saw, or what was it that made you want to be, a litigator, somebody that tried cases when, your dad did not do that as much?
I'm a bigger jerk than my dad. I like to fight more than my dad did. He was like the most peaceful, non-adversarial person on the planet. I think I've adopted some of my mother's personality characteristics, or I inherited them. And so I was always someone who had to prove that they were right and had to fight about every last issue. And so, everyone knows that is part of the law. And I knew that the law sort of fit my personality, generally speaking. That's like what we do, is advocate for a certain position. But it always seemed to me that, trial work lent itself much better to my personality than reviewing employee benefit plans all day and advising clients on that. So it wasn't a book, and it wasn't a particular, I've always sort of had a civil rights bent. And, again, the thing that gets me going in the morning is, like, it's proving I'm right, and, like, drives my wife insane and everyone that I know probably. But that's, I think, worked out well for my career.
Yeah, it's a good trait to have for our practices. I share that with you. I think probably a lot of trial lawyers share that as well. But it's also can be problematic outside of our practices with interpersonal relationships and friendships and family members and so forth. So you kind of have to, try to do our best to evolve and balance those, I think.
Well, you have to have some introspection about it and self-awareness. And also, I'm very lucky that my wife is a mental health provider, and so she can tell me when I'm being too much of a narcissist or something like that. And so, but to be good at what we do, you can't be too much like that, because a jury's not going to like you. But you certainly have to be confident in your convictions. So,
well, yeah, I think it's, I liken it to, I think if I, God forbid, I couldn't be a trial lawyer anymore, what would the next most likely sort of area of work that I could maybe transition to? And I think sales, in a sense that, and I think that if there was a product that I truly believed in, sort of like my cases, I could sell that. I could tell people passionately why I think they should buy it, which I think is very similar to, what we have to do as trial lawyers with the jury. And I think sometimes, I don't know if you've been there, but, our cases are of varying strengths. And sometimes you really kind of have to work hard to find that part of it that really resonates with you, because I think if you don't believe it, you don't believe in your product, you don't believe in your case, the jury can smell that in the second you stand up to talk in opening, I think.
Oh, absolutely. I mean, are there cases that are not like that? Every case that you go into, I'm a person that's got healthy skepticism about everything in life. And so, you know, those defense lawyers start shooting arguments about this, that, and the other thing. And probably my initial reaction is, well, you know what, they're right. Maybe I should just drop this case. But, that our job is obviously to fight past that.
Well, I think that's a really interesting, phenomena that we deal with. And I don't know if there's like I never did any defense work, but I always get the sense that there's like some class that defense lawyers take to, where they're trying the case way before the trial ever happens to get in your head about how bad your case is. And I think as a young lawyer, that could really mess with you until you realize, like, oh, that's just the shtick that everybody does on that side of the fence. But I mean, it can have a big impact on the way that you look at the case, how you value the case, how you talk with your clients, if you're not super aware of what's going on and the point of what they're trying to do to you.
100%. But I mean, also, I would say if you're totally disregarding their arguments, then that's pretty foolhardy too, because a jury may buy it hook, line, and sinker. So it's you have to, all those arguments that when you get to tunnel vision and you would think, my case has no flaws and I'm just marching forward. I think you have to take into account every argument that the defense makes and figure out, when we focus group the hell out of our cases, figure out how am I going to deal with this, how am I going to deal with this, and when I get up in trial, like you said, in voir dire and opening, how have I become comfortable myself with talking about this particular issue in a way that's going to disarm the defenses.
Well, definitely want to talk about, the focus groups, because it sounds like you probably did some for this case. But yeah, I think it was Charlie Munger had the line that, you really shouldn't have an opinion about something until you understand the other side's position better than they do, which I think goes to your point that, defense may be actually making some legitimate points sometimes, even though it's painful to hear. One thing I'd like to hear from you. So, you want to be a litigator. You start practicing. You start trying cases, and I know because I think that over the years, I bumped into you on different listservs. Probably maybe one of the reptile listservs at some point in time, and so I know that you are a student of our game. And I'm curious, as you look back over the years of your practice. What were some of those, after law school biggest trial influences on the way you practice?
People, I mean, definitely Don Keenan. Firm-wide here, we do a lot of Keenan seminars, and that probably weighs in most heavily in every case that we try. But, Keith Mitnick, definitely read and reread Keith Mitnick's stuff before every case I try. Rick Friedman, the usual suspects. But definitely, I would say of all people, Keenan Trial Institute is very heavily influencing every case that we try. Every good success that we've had at trial is a big, I think, thank Keenan for those.
I'm the same way. For many of my verdicts, the first thing I would typically do afterward is send him, just kind of a thank you email. We got a good outcome, and you had a lot to do with it, and David Ball had a lot to do with it, and just kind of provided us, I think, a lot of structure. Because I think when you get out, you don't really, you have ideas of like what you're supposed to do, but it really helps to have some guidelines. And not that, I'm not as dogmatic as some, but I think it's really helpful to have a basic structure to follow or think about when you're approaching trial. And then, you can deviate some as you learn other, helpful stuff that resonates with you and stuff. But just that, I think the kind of basic blueprint that, the Reptile on the Edge and Keenan Trial Institute have provided us is just immensely helpful still to this day. And I think Reptile came out in '09. And here we are 15 years later and all still benefiting from it. So it's pretty cool.
Yeah. Yeah, I shouldn't. David Ball, absolutely. I mean, we've gone down and done like all-day meetings with David and Artemis on cases before. And every time you attend a seminar, every time that you do something like that, it adjusts my paradigm, my viewpoint on all of the subsequent cases. And in a way that, that has absolutely molded who I am as a lawyer today.
And, a lot of the guests that I've interviewed up to this point have, referenced the same thing or, hit them up for openings or closings. And you can see so much of that, a lot of the same kind of aspects or structure to opening and stuff that a lot of us are using, maybe with, a few tweaks here and there, but I just think goes to prove how effective it is, just big picture, and continues to be effective, as we go on.
Yeah, there's no question. You talk to juries after each trial. It's the stuff that is tried and true. You got to make it your own. Obviously, you've got to fit it to your personality, but it's pretty close to what they're teaching. And you talk to juries after trial, and that's exactly what works. It makes sense.
Well, let's talk about trial. So, I want to hear all about, Cheryl Trout's case versus, what is it, JDev 8 doing business as Mr. Hero, right?
Yeah, ubiquitous JDev 8 conglomerate. So our client, Cheryl Trout, 60 years old at the time, JDev 8 or J Shanny Dev 8 is like a brother and sister owned one franchise of Mr. Hero, which is a Cleveland area fast food. I don't think that they're outside of Cleveland, but it's a fast food joint that there are maybe 20 or 30 of them in Cleveland. And so she goes in to pick up food for her husband, who was very sick with stage 4 bile duct cancer at the time. He was really not eating, but that day he had a hankering for Roman burger, which is one of their specials there. So she goes in to get him food. She's goes up to the counter, orders him the Roman burger, goes back to wait for it. And then when she was called up, when the order was ready, she's walking up. She feels something wet under her foot. Foot slips out from under her. She lands on her right knee, and the knee shatters into 8 pieces. And so that's basically the case. Then immediately they call EMS. When EMS gets there, the manager, the brother and sister that run the place, their first reaction was to say she spilled something and slipped on him. Now, she didn't have anything with her, period, but that's what they told EMS, and that was obviously a helpful thing that we ran with that trial. But then later on, their defense of this case through and through was that we went and inspected the floor afterwards. There was absolutely nothing there, no wetness whatsoever. We had surveillance video. We went and reviewed it afterwards. There was absolutely nothing that she slipped on. She just fell. Now, that surveillance video that they had, they let get overwritten after a week. So that was something that really, they, from the start of the case, tried to use as a defense of theirs, that we watched this video and it showed that nothing happened, but then obviously like focus groups and sort of intuition was that it doesn't really look good if you're saying that you had this surveillance video and you let it overwrite, but you're saying it supported your defense. Like the try the lie theme was definitely heavy throughout this case. Like, not only did they let the video go and they told, initially they were telling the MTs that she had spilled water and slipped on it, but then we went and looked and there was no water. So that was a big issue that we blew up. And then, there was, in terms of like what Keenan would talk about, credibility. I mean, every trial, obviously, like we have to dig deep to make sure that we are more credible and believable than the other side. And so, like, being off code, the defense lawyer in his opening said that this franchise, J. Shanny Dev 8, is owned by Indian immigrants who are not great English speakers. And so from the get-go in opening, defense counsel talked about how we had sent preservation letters, like immediately. She had hired us and we sent preservation letters immediately after this happened to make sure that video was retained. And he actually, in opening statement, and this was like manna from heaven for us, said that we're just making this, we're hounding his clients and making this story up about what happened because his clients are not native English speakers and taking advantage of them because we're slick, fast-talking lawyers, and we cross-examine them. You're going to see how they just, if they admit things, it's just because they don't understand what's being asked of them. And so, from voir dire on, like, my MO was, I cannot come off that way. So that was like my focus with voir dire. That was my focus with when I cross-examined all of these people who, sort of the main guy, truly, his English is not very good. And I actually got admonished by the judge at one point to stop cross-examining him, even though he's the manager and a part owner of this restaurant. He didn't want me cross-examining him because if I could get this guy to say yes to everything if I wanted to. But so I just had to a big part of this case was just not being a bulldog like you may want to be during cross-examination, just really taking it slow and not coming off as taking advantage of these folks. We had a big concern going into this trial that even before, while the way that defense counsel went so far to attack us in opening was, I think, a gift to us, we always knew that you got to sort of take it easy with these crosses and how we talk about the defendants, because I think a jury could really get pissed off at us if we seem like we're taking advantage of them. And so we knew that going into it. But I thought, one thing that I really tried to exercise a lot of restraint in that fashion, and I knew that was something going into it that we had to do, and that was something that the jury talked with us about afterwards, that they thought that we were very professional and did not, again, when you talk about Keenan stuff, we're very off code for lawyers, versus what I think defense counsel is playing into the black hat stuff that Keenan would talk about.
What did I often am more, and I don't know if you're like this, but my default is probably further on the aggressive end of the spectrum on cross than the softer and easier. And I think most of the times it's to, at least my benefit, to dial it back towards the, softer, more compassionate cross in most instances. Did you, whether it was working with your wife or meditating, but did you focus on something to get yourself in that right headspace to just stay in that kind of zone of not overly aggressive, not antagonizing, and trying to stay off code?
Yeah. So, I mean, I feel like in terms of my natural tendency is to be more attacking. And there are times when that's appropriate. If you have a defense expert who's battling with you, sometimes I think that has served me very well in trial. I'm like naturally sort of a sarcastic person. I think there are times that like the proof's in the pudding, it's worked. But here, I knew it going into the trial that I said to Katie 10 times, I can get this guy to say yes to everything, I'm sure. The transcript will look great if I do that, and we'll lose the trial. So I knew it going in, and it was palpable. I think, the defense witnesses were liars, but they came in and were so nervous and it wouldn't be the immediate reaction that any juror would have to these people that they were lying about this. Like, we had to establish the credibility and prove that through the facts. And so it's just like, it was natural going when I started cross-examining and seeing the reaction and seeing how these witnesses, particularly his first witness. Once the first witness was done, I knew, okay, this seems to be working. But it wouldn't have been any other way once you get into it. And if I just was steamrolling over him, it would have been so bad. I mean, just as I said, it was like palpable in the room that it was easy enough. It was hard to restrain myself because some questions, of course, when I was asking him questions, he would react as though, I don't understand what you're saying. I don't understand what you're saying. Then his counsel gets up and directs him and redirects him. And it's like every question he can answer just like that. But despite that, what are you going to do? Are you going to get up there and say, oh, it's really convenient how you can understand your lawyer every question you ask? It took restraint, but it's like something that you knew, like this is kind of a make or break moment. So I just marched through it very, very slowly and methodically.
What was your, in the discovery process, you've got a franchisee of a larger franchise. Did you have a particular approach of themes or areas that you were trying to develop in discovery, be that from what you were learning from early focus groups or just thoughts on how the case that, you think kind of helped, find the winning frame for the case for you?
Yeah, I mean, my partner and I tried a case in like last September, a med mal case in not a great jurisdiction in Ohio. We got a really nice $6.19 million verdict. And obviously like past cases and Keenan and all these folks that I talk about would say the same thing with, rules. You have to frame your entire case around rules. And that's obviously like something that we try to do with every case. So it worked well for us a few months ago. In this case, we had an operations manual by the franchisor that wasn't being followed whatsoever at this restaurant. Now, in terms of how focus groups felt about that and whether is it so critical that a fast food restaurant follows this rule versus that rule? There was some ambiguity when we're running focus groups about that issue, and that we still felt like that's the approach for this trial. We had to explain to the jury we going into this case, and even throughout the case, we really had no proof of what she fell on, how long it had been there, why it was there, and so you had to lean on something as to why that happened. So our message going into it is our investigation in this case, we talked about this in opening, our investigation in this case is what was there and why was it there. And, we had to sort of piece together from a bunch of circumstantial evidence here and there what was there. And as to why it was there, we leaned heavily into the little bit of an operations manual that applied to this restaurant. And they did admit, when they got the license to run the restaurant, that they had to follow the operations manual. And we found, we looked at 6 or 7 provisions in the operations manual that if you did these things, you would have discovered this spill and you would have prevented it. In the jury here, we talking to them after the case, they did go with that. But again, we focus group that issue multiple times, and people were kind of all over the place on that. So I think that what mattered was we had a lot of evidence of sort of like lies that we had developed through discovery, things that just didn't make sense to jurors as to why would you let the video go away. They didn't create an incident report that required by the operations manual to create an incident report. They didn't report this to corporate until weeks or months later when they finally sort of got our preservation letters and acknowledged them and what have you. So, in terms of discovery and like what really we based the case on, it was kind of like the tail wagging the dog to a degree, where it was really the sort of cover up stuff that gave us arguments about the other things that we developed in discovery. Now, discovery wasn't like, not everything was favorable for us that we uncovered during discovery, because this restaurant, every time that the parent did their like every 3 or 6 month inspections, they would do random inspections of the restaurant, just have like a secret chopper come in and do full inspections of every aspect of the restaurant. They were like pretty glowing through and through. So that was an issue that we had to confront during trial, try to keep that evidence out, frankly. But this came out pretty good at trial. One time when there was an inspection, the parent had said, "You're not putting the dates on the refrigerated food of like when this package was opened, and that is a health department issue, so you got to correct this." So, I think one thing that I've had that has allowed me to be successful as a trial lawyer is like I prepare. I mean, obviously, like prepare like none other, and I know the case. I know when I go into trial, I'll know this case so much better than defense counsel. So, he brings in these inspection reports, starts talking about them with the owner of the company. You guys have always had 98% and what have you. And so, but then I crossed him and he had no idea that this was coming, because this is not something that was at all brought up in depositions. In fact, I think maybe we got the inspection reports after most of the depositions in this case. I brought up the inspection report that had this like potential health code violation. In fact, the parent said that if you don't correct this in 10 days, we're going to shut down your restaurant. And so, I kind of went through with him and said that this happened. But this is not representative of how you guys operate the restaurant every single day, is it? And he said, no. I'm like, so, in fact, you would say most days you don't operate it this way, right? So these 12 other inspection reports, that's just 12 out of the 1,400 days that the restaurant's been open. So we can't just draw from these other 12 days how you operate the restaurant every other day that it's open. He said, like I said, these witnesses were not combative at all. He said, yeah, that's true. So, I don't know. I mean, questions about discovery, but that's kind of like how the discovery played into the actual trial case.
So I'm curious about, you have one of these cases, and I, before we jumped on here, I told you I was particularly interested to talk about your case because it has so many similarities to a slip and fall I'm going to be trying in about a month and a half. And one of them is the essentially battle over, what, if anything, the person actually slipped and fell on. And in my case, my client says she slipped on water. We don't know where it came from. There was a picture taken, doesn't really show it all that well. Similar to your case, she slipped, but she's there by herself. She's not, her husband's at home, no other witnesses at the time. She self-reports, I felt the water in my pants. It sounds like she told the paramedics. But then you've got the other side, diametrically different, saying, no, we went and looked. There was no indication of anything and that she just fell. And so one of the things I'm curious about is her, in her background, were there any issues with her having fallen before, ever having filed, any personal injury lawsuits, anything like that in her background?
No, we had a pretty impeccable client, so that was obviously a nice thing going on. I mean, there was just nothing to beat her up about. She was wearing flip-flops on the day of, and they tried to sort of insinuate that was the cause, but then, I'm like a horrible, the old adage of you shouldn't ask a question on cross-examination that you don't know the answer to. I pretty much disregard that rule entirely in my practice. And so, one of the cases I tried recently, I told the defendant doctor to go home and do medical research and you can bring in the next morning any medical research that supports his opinions in the case. And then he actually did that. But it still worked out, and we won that trial. But so here, they had, like in terms of what she fell on, the manager said, I watched the video and there was no water there. I said, well, what did you see in the video? This is something that hadn't come up in discovery report. Like, did she trip over her shoe or something like that? You guys are saying, your lawyer is saying that her shoe was the cause of the fall. Did you see that in the video? And he said, no. And we sort of knew that he couldn't really say that because of what written discovery responses, like they had never identified before what the reason was that she fell. And I was prepared to say, well, how come you didn't bring this up in the time you were deposed before written discovery? So in our case, sounds like versus yours, we had pretty good testimony from the EMTs about one guy was pretty sure that he saw, he's like, I was focused on treating the patient, but I'm pretty sure I saw water on the floor. And then the other EMT said, I'm pretty sure that her pants were wet. One thing that focus groups brought up that was, of some concern, well, she had a horrible fracture, patellar fracture. And so they brought up, well, did you wet yourself because this was such a bad injury? And so we dealt with that. The EMTs did come in and say, did you evaluate whether that might have been from that? And they said, yeah, we had to, because we had to make sure that she didn't have a stroke or something like that.
Paralyzed or something, yeah.
Yeah, exactly. So so that's how we dealt with that issue. And obviously, our client was extremely credible and said, I didn't. I slipped. My foot went in something, I slipped, and I landed on me. So, but I think, ultimately, that whole issue and the dispute over was there something there or wasn't there something there, we polarized the hell out of this case, and that's something that I'm sure you got to do too. And that comes down to being off code and not coming in and being the more credible side of the two. And at the end of the day, I mean, this happens in med mal cases with us all the time, that the defense is saying, there's nothing in the medical records that supports what you're saying happened. And we would have documented that if that happened. And you just have to paint throughout all the evidence that you're presenting here. You're saying there's this fall happened for absolutely no reason. I mean, you can't say this person who's never had a history of falling and has no history of making claims, whatever, that this time her fall was just out of the blue. She just dropped to her knee, even though we've got this point of evidence, this evidence, this evidence, and this evidence. And that's the same like the case that we just tried 6 months ago, med mal case. It was a fall, a brain injury in a hospital. And their whole argument was, we had an argument that, was all about, you loaded this guy up on 7 new medications, and they all have a tendency to make someone hypotensive, and he fell because he was hypotensive, and that's what these medications all do. And so even though there was no documentation contemporaneous at the time, because you guys didn't do your job to show that he was hypotensive, that is what these medications do. And their defense was that you've got no proof that didn't happen, whatever. So that's I think on these fall cases, framing the issue throughout the case as our version makes a lot of sense. There was something here that caused this fall. Your version is that we have no idea. This person who otherwise is capable of walking just all of a sudden dropped and had this horrific injury.
Well, and I always think about Paul Rivera's statement of trial is a battle of impression, not logic, and And that's true in all cases, but I think premises cases in particular. And I think you're dealing with this case, and this is not. I mean, you had some nice facts, but it's not an easy case because you don't have this clear thing that clear violation. You don't have a clear indication of what exactly she fell on, or why it was even there to begin with, or what exactly it was, and that can be really problematic. But I mean, I don't know if this has been your experience, but in mine with premises cases in particular, that if you have a very good and credible client, that goes a really long way. Because just the overall impression of the consistency and like what you said, what makes sense here? Does it make sense that this person, and Miss Trout was what, 60 years old, you said?
Yeah. Mm-hmm.
So, I mean,
Yeah.
that she's, in her entire life, she's never fallen, never had a major fall whatsoever. She's never filed a, personal injury lawsuit, anything like that. And, just randomly, after all that time, goes to this particular restaurant that also is having all these problems. There's missing video. There's no incident report. There's, not following the corporate. It's sort of like none of those things individually carries the day, but the cumulative effect of adding all those pieces together, the impression of your case making sense that they screwed up somehow, and there was something there that this woman shouldn't have fallen on, and that's what caused her fall, I think kind of carries the day. But let me pivot into from your focus groups. From the focus groups you did, what was your takeaway? Like, what did you learn about, okay, what's the best way for us to frame this case? What are the best rules? What's the best evidence for us to focus our case on?
Yeah. I mean, as I alluded to before, I would say it was a case that concerned me. Okay, slip and fall cases that we've focus grouped before or tried, they're scary to me because I don't think that we've had a great track record historically in focus groups of like really honing in on, if you present the case this way, you'll win. I mean, you get mixed reaction to it. In our case, there was certainly a theme from focus groups that people were dubious of. So they not only did they say that that they that they not only did they not have the video, they said that the reason why they didn't have the video wasn't that they didn't want to keep it or whatever. It was that they didn't know how to save a recording. They never had to do that before. They, it just didn't cross their mind here, and it wasn't like readily available to them. And so that was something that we hadn't really planned on before the focus groups, that like really honing in on like the truth of that whole. I mean, it seems kind of not plausible to me and you, because you're thinking like, well, I don't like, did you take out a phone and try to record it or anything like that? Which is, so honing in on that was definitely, it's just the try the lie kind of mentality. Like, let's really prove that no reasonable person could say that. And then again, we had kind of a great, fortunate bit of testimony that the like sort of not present owner, it's co-owned by brother and sister who actually work there, and then another owner who's kind of like, he owns multiple Mr. Hero franchises, and but he's not on site really ever here, but he's kind of the president of the company. He said something during cross-examination like, well, I'm sorry, I left out the fact because she had heard that the manager and the employees blaming her to the EMTs. She told that to her granddaughters, her 18 and 17-year-old granddaughters, as she was at the hospital that day. And they got all ticked off and ran to Mr. Hero and took a video of their conversation. They just wanted to confirm, like, you say that happened? Well, do you have surveillance footage? Because my grandma is not a liar, and she says, I did not spill anything. So the owner of the company said, well, why didn't they at the time ask to see the surveillance video and video it on their own phone if they really wanted this information, whatever? And so I asked the owner of the company, well, why, if you wanted the 18 and 17-year-old granddaughters to do that, why didn't the manager of the store, why didn't you tell him to do that? when this fall happened. So definitely, like, I think that was probably the theme that we got most out of focus groups, was like, the more we can show how ridiculous these like explanations for why they didn't create an incident report, why they didn't save the video, that was the thing that was going to win us the case. Because slip and fall cases, there's like tons of negative attribution. I asked during voir dire, some people that would, slip and fall case, some people would say that the person who falls always shares some of the responsibility for that. And then I also added, like, and in this case, you're going to hear like she's got these flip-flops on. Some people say, like, no matter, I don't care what happened, that you shouldn't have, then we got into the theme of like, it's ridiculous to say someone's negligent for leaving the house with flip-flops. But, those were kind of some themes that we got out of the focus groups, because they also, there are a lot of people that would, no matter what evidence you present to them, they're going to say slip and fall case, or slip and fall where someone's wearing flip-flops, I'm going to attribute some fault to the plaintiff. So we certainly try to get those people off the jury. Now, that being said, I got two of the jurors on the panel to say that because of those types of facts, we would have to prove like 75% or more for us to win this trial, and the judge did not kick them off for cause. So, but at least I then used peremptory challenges on them. So, but that was I was thinking, like, okay, well, that's about as clear as day.
Yeah, right.
You should come off the jury. But those were things that we heard from focus groups a lot. That, I don't know, people should be watching where they're going, and why is she was in the store for 10 minutes. Why is she any less culpable than the person who's at the register? That kind of stuff.
Did you gather any information from the focus groups, or did you have, a hunch yourself of some type of, whether it was a thought process, belief, or demographic in the jury pool of who you wanted in this jury or who you did not want? Like, going in, were there people you're thinking that I'd love to get X, or we need to watch out for Y?
Yeah, I mean, sort of what you might expect, reptile edge. I didn't want 60-ish-year-old women on the jury. And we did have one, and she was great, actually. I mean, through voir dire, you can kind of tell that she was great. But every single time she'd be walking in after a break, whatever, she'd like smile at our client, which was good. But, I think by and large, and we had some on, there were jurors that we had to boot off. One of the ones who said 75% she would require, women of that age are thinking like, I don't want to fall and fracture my kneecap and have difficulty walking for the rest of my life, so I will pay more attention. And so that was definitely a theme with focus groups and in trial jurors that we didn't want. But, like, kind of, maybe this is surprising or not surprising, whatever. Focus groups, we had a fair amount of people that had worked or managed fast food restaurants before. And I think by and large, they were not bad, wouldn't have been bad jurors. We didn't end up having any potential jurors who had any significant experience working at fast food restaurants. But I think, they all saw the bad side of it. Typically, like in that Mal case, sometimes might you be okay having people that are in the medical field on the jury, but, it's usually not the case. But I think, slip and fall case, depending on the industry, I think fast food industry particularly, you could have some good jurors that way. But really, the one group that we wanted off, and like the potential jurors that during voir dire, like, made this abundantly clear, that women that were of that same demographic were not going to be great jurors.
Yeah, and that is, I think, counterintuitive to a lot of people when they first start practicing, but oftentimes that is the case, that some of your worst jurors you could get are people that are very similar, have had similar experiences or injuries as your client. Can you, I loved your opening, which you were kind enough to share with me, and it obviously has a lot of the classic, reptile structure. You started with a statistic, you move into the, why we're here, rules, and then, pivot into the story of the case, focusing on the defendant. Couple questions for you. Did you have any type of a premises expert in the case?
Yeah, so I actually, first of all, we scratched the statistic during trial because I
Okay.
thought that's not even, it's just not a great statistic. There are plenty of cases where we have good stats to rely upon, and I think they're really helpful to use in those circumstances. But this one, like, it just wasn't,
I mean,
you
why
know,
why not? I actually thought that was sort of an on point one. It was like 1 million people slip and fall in restaurants every year. Did you think that like it almost makes it like, well, it's just something that happens a lot, or?
yeah, and I thought that it just, like, our experts, if I'm going to use a statistic during opening, I wanted the experts to really come through and say, and everyone knows this, and so the whole industry adheres to this, but like that particular statistic just wasn't. We weren't going to have a good expert. We identified two liability experts. We brought one in to trial.
What kind of credentials did they have?
He was great. I mean, he was like the biggest fast food franchisor or franchisee in in the state of New York for like 30 years. So he ran a whole bunch of Arby's and Burger Kings and Friendly's restaurants. And it's actually interesting. Like the defendant, the defense counsel kept saying like, yeah, well, this guy knows everything about how to run franchises because he's like Mr. Corporate and had such great success. But you shouldn't hold my client to the same standard, which was like definitely something that probably wasn't a stupid argument to make because I think that there are some jurors that might resonate with, but it didn't really work with anyone here. But yeah, he was. I thought he was great. He was a super likable guy. His name's Larry Kessler. And really, did he have to pull a lot of the weight here? Is it sort of eminent common sense that restaurants should run according to their policies? I mean, that's fundamentally what he was saying. But I just thought that he was a likable guy, and so it's just, and he was a guy who would go into his restaurants like 5 days a week. He'd go into a new restaurant. One of his, he had 80 or 90 restaurants at the peak of his career. He would go into a restaurant every single day. He's like semi-retired now, and so again, it was like something that defense counsel like tried to use against him, like, oh, your standard is way higher than these ones. And in fact, like this was a really, I thought, stupid move by defense counsel. Like he said things like during his closing, like, we don't have to be an A+ in order to win this trial. If we're operating at a C, or he said something along those lines, if we're even operating at a C, we win this case. Which I didn't. I mean, by that time, I think the case was lost for them anyway. But yeah, I mean, I think that that's like kind of a message for any kind of case where you've got an expert who's maybe more qualified or whatever than the defense. You got to have them, though, be able to pull across the line in terms of like what to expect out of someone that occupies the part of the industry that the defendant does.
Right. In your couple questions about your opening structure, so I follow very similar structure most of the time. I was curious. I mean, you said earlier, you're also a big fan of Mitnick, as am I, but in your sort of undermining section, you did the more kind of classic Ball, Keenan, that before coming to trial we had to determine a few different things, and I personally over the years have come to like better the putting things in context approach by Mitnick in that section. I don't know if you've ever tried that one, or do you generally like, and why do you like that idea of like before coming to trial we had to determine X?
To me, I think, at least when I'm the person speaking, I feel like it's more genuine and credible for me. It's like I said before, like I think you have to, when you get defense expert reports in, think like, okay, well, how believable is this going to be to a jury, and what's my genuine good faith explanation for why this is inaccurate? And so that's kind of the thought that I have going into an opening, like, okay, we genuinely did have to, if what they're saying was true, we wouldn't have brought this case to trial or whatever. And so, like, let's talk through, this was an issue that we had to look into, this was an issue that we had to look into, this is why we determined that, this wasn't a reason that the defense should win.
I like that.
And so it's like with all of these, I'm not Keith Mitnick or Don Keenan or David Ball or any of them. So it's like I have to sort of, everyone does have to like model these things to what resonates more with them, what they feel like they can genuinely present in front of a jury.
Well, I think that's a great point. I think, like, I can think back when I, first, reading damages and then reptile and everything, and I was literally at times in, like, say, an opening or different, I would say something that I read, and I didn't even totally understand, like, what it meant. I was just like, oh, well, that's what they say to do there, and it's not until you really process, like, well, why, like, what is the purpose of saying that thing they're recommending there? And then when you understand it, you can kind of say it in your own words and get the same concept across. And that's the main point. But you get in a lot of trouble if you just try to, regurgitate something you read somewhere without understanding the reason for it.
Yeah, I mean, like, I'm a very different person than Don Keenan. Even though I would say that Don Keenan, his strategies are as good as they get, I'm a very different person than him. So if I just literally tried to spit out what he does, it wouldn't come across as genuine whatsoever. And so that's with all these people. I mean, same with Keith Mitnick. They're they have different personalities than me for sure. If you can adopt that to how you practice, it's great. But you have to be cognizant of, like, is this going to come off as completely disingenuous?
Yeah, it's got to be. It has to be you. That it has to be like how it. You understand it. You learned what the concept is, but it's got to be now your way of doing it, or else it's a disaster. But I loved, and I'm going to totally rip this off in my next trial coming up, the way that you approached undermining, really the kind of the critical issue in the case of. You're, Miss Trout saying, I slipped on some type of liquid and that's what caused me to fall. And they're saying there was no liquid there. We went and looked, there was nothing there. And you polarize them and you tell the jury, look, this is what you're going to hear. You're going to hear two diametrically different versions of what that issue is. But then your tiebreaker, which fortunately I have in my upcoming case, is that, look, we could have known definitively what exactly happened if they just kept the video. There was literally a video of what happened, and that they possessed, that they recorded, but that magically they don't have here to show you. And I think you do those focus groups, and I think I don't know, I consistently see the jurors saying, it's not so much like that, like, oh my God, like they're at fault, but it's just like, that doesn't feel right. And it's just that like feeling of like, then now your version's the credible version now.
Yeah, absolutely. I mean, that was certainly a theme of most focus groups, that fact alone seems not credible to them. That being said, I mean, we certainly got from the focus groups, it's better if we can go beyond that and just explain why that's so not credible here.
Well, how did you do that?
In our case, again, we had the defense lawyer tried to paint us as we're just trying to shake him down from day one, and we're sending preservation letters, and his poor client, this, that, and the other thing. And they had this video, which was, a blessing and a curse for us, of the granddaughters going in saying, you made up this story about our grandmother, and I hope you have a security video, and how her medical bill is going to get paid. And like, genuinely, they were concerned about these things, and like, it was not, they're kids, like they didn't have any kind of ulterior motive. This was genuinely their concern. And so, we just kind of took that as, okay, well, on the day that this happened, you knew that she was claiming that she slipped and fell in water, and you guys were claiming that there was nothing on the ground. You knew that she fractured her kneecap. You knew that she had medical bills that she didn't know how she was going to pay for. And in whether or not you're following your manual, you knew that like you have all these policies about what you're supposed to do in the case of an incident and turning it over to the insurance. I mean, obviously I didn't say insurance carrier, but like, you know, and you knew that you watched the video the next day, and you say it whole through and through supported your position, and you did zero to try to actually, you didn't look up the manual, you didn't Google it. So like one thing that I had prepared, I didn't actually have to use because I think it would have been too complicated to a jury and with a non-native English speaker, is I just Googled that make and model of the camera. They didn't have the owner's manual, but I Googled it and I was like ready to use on cross-examination as necessary. Okay, well, like let's look at this, how to save a video. And as it turns out, the same screen where you would be watching he must have had to go back 12 hours to view the video after it happened. And I did sort of go into this. I'm like, so you knew how to access, you knew how to load the app on your phone. You knew how to access the app. You knew how to rewind it 12 hours and watch this time before, but you couldn't figure out how to watch a video. I asked, did you know I Googled how to save a video on that? Did you know that it's on this very same screen where you're watching the video? There's like 4 buttons on there, and one of them is record. And he, just said no. But I was probably much more sarcastic in the way I just said it to you now than at trial. It's like on that same screen, did you see that there's a button for that? And, so I think that's kind of how I think, this is of course like just my guess, but I thought that's how we sort of brought it across the finish line. Like what you're saying is so implausible. Like between that, you didn't report it to corporate, you didn't make an incident report. These things are all like, you're clearly trying to cover it up. Whether or not they really, I don't even know now looking back on the trial, whether they really knew they were trying to cover it up or just like whatever, they just want to sweep it under the rug. They didn't want to deal with it. And so I think that's probably actually what was going on. Then like consciously like, oh, what are we going to do to try to prevent anyone from knowing that there was this incident?
So let me hit you with some interview potpourri, just kind of jump around with some different questions I'm curious about from the trial. So reading your trial statement, your client had medical bills and some other, decent but not overwhelming economics. Did you put those into the case?
Did not, no. Yeah, and I voir dired about that. I thought this was a good voir dire question or statement that I created that I didn't ask the jury specifically about it, but I said like, Ohio law permits us to put on these medical bills, but fortunately they didn't end up, you're going to hear on the video that their granddaughters were concerned about it, but fortunately they didn't actually end up having to pay out of pocket for those medical bills. And so for me, could we come in here and ask about them? Yes, but I feel like it would kind of be double dipping. And so, because in Ohio, the defense lawyer can, not only did she not have huge medical bills, the defense lawyer can put on evidence of what was actually accepted as payment in full. So, that number, even with futures, might have been like $60,000. We thought that's not a number that we want to show the juries. And on the high end would have been 105 or something like that. So, talked with the jury about that, and I thought that was an effective way, and hopefully bought some credibility points for me. So, but no, we did not put on any evidence for economic damages. And talk about that during court. It was like, and we got, that was part of what got these people to get to 75% proof that they said that they required, I think was, it's a slip and fall case, and we're not going to be asking for any economic damages. This case is all going to be about for human damages. And some people are very uncomfortable having a trial that's about that and awarding significant damages. I'm telling you right now, we're going to be asking for significant damages because she's lost a lot here. So, but that was, sort of, we waffled on that a little bit because it's a slip and fall case. And like, I like them, but I think they're hard to win. Yeah. And so I was kind of thinking like, what gives us the best chance? Is it at least something to say she got $100,000 in medical bills. So.
Did Ohio, you're able to ask or suggest a number for the pain and suffering in closing? What did you suggest or ask for?
We asked for $3.4-ish million, and we based it on, sort of Mitnick like formulas of it per step. We had our expert talk about how many steps does the average person take per day, how many steps is Cheryl Trout likely to take, per day, per year, stuff like that. And like if you had approached her on June 7th, 2021, and say, we're going to do an experiment, and what is the amount of money that you would accept? And let's talk about all the things that you're going to go through. Your husband's sick with cancer. You're the primary caregiver. For the next few months, you're going to have to sleep in separate bedrooms. He's going to have to try to get up off the couch as best he can to, instead of you taking care of him, that he can take care of you because you can't move. That kind of stuff. So that was our non-economic damage approach in closing.
Did you talk with anybody, or do you have a sense of, so obviously we know you put that number out there, and typically it serves as, sort of a starting point, an anchor, a tug number, whatever you want to call it. And oftentimes the jury is going to, work down from there most typically. Do you have a sense, or did anybody indicate to you like why or where the 1.3 came from?
I mean, they just awarded us. On our interrogatories, we got all the lines for past pain and suffering, past mental anguish, loss, consortium. We had lines for everything. So I think they just kind of. We didn't really talk about that specifically with the jury. I think they kind of like assumed, as jurors often do, that we're asking for more than we actually thought was the right number, and that they gave us something for all of them, and so that's kind of how it worked out. And they did, in this case, they awarded, appropriately so, as I often say during closing argument, I did here, like, juries get it right, and so they awarded most of the money for the period of time that she lost with her husband during the last 18. So he passed away during the litigation, and like 18 months after her fall. And so they awarded most of the money for her claim and for his claim for that time that they lost together.
Wait, so was there a consortium claim? Because I saw only her name was on the caption.
Yeah, no, there was. So we opened up an estate for her husband, and so there was, he was a plaintiff, and then opened up an estate for her husband and substituted him in. And so I think they awarded like $250,000 for his consortium claim.
Were you able to preserve any of his testimony before he passed, or did it happen too quickly, or just not happen?
We did, but we didn't. So we would have had to just have some. All he did was give a deposition that was not videoed. And we just thought it was better to present his testimony or what happened with him via friends and family members versus even reading his deposition, which was, was great, his deposition, but it just wouldn't have been that compelling. So we just had, before and after witnesses talk about this is how it affected them. This is the kind of people they were.
Any other, so for, you're on the other side of the case and you can look back on, what worked, what maybe didn't work. And I feel like you always have like the most clarity afterward when it comes together like this. But, for somebody else going, myself, I'll be trying a, sort of similar case soon. What would you say are the biggest, factors that led to such a great verdict in that case, that maybe are likely to apply to a lot of premises cases?
Yeah, I mean, I just keep going back to it being off code. Those cases so often come down to credibility, and obviously you're going to want to have a great client in that regard, and we did. But you have to be just as credible. The jury isn't going to reward your client if they think that you're a quick talking liar, embellishing facts and stuff like that. So I think through and through at every instant of the trial, you've got to be thinking about being credible, being yourself, being genuine. That's true of every case, but particularly one where, I don't know, it seems like most medical cases are not as much. You do a lot of med mal trials. Obviously, you have to be genuine, what have you, to win those too. But I think that you can be a little bit more aggressive or whatever in those cases. Slip and fall, I think you just really have to. Particularly this one, like, knew it going in, turned out to be true. Slow it down. Be as credible as possible from A to Z in the case, and that's the only way to win.
Awesome. Well, I think that's a good stopping point, Scott. I appreciate your time, and congrats again to you and Katie for an awesome verdict on what are always tough cases, and there was a lot of unique aspects of your case that you had to adapt to and strategize to help your client get such a good outcome. So congrats again, and thanks for doing the podcast.
Thanks so much, Brendan. I appreciate it.
Absolutely.
If you enjoy the show, please subscribe to the Just Verdicts podcast on your favorite platform and consider leaving a review. And if you're interested in co-counseling, local counseling, or referring a catastrophic injury case, we'd love to work with you. Call us at 412-281-4100 or visit our attorney referral page at pamedmal.com/refer. Thanks for listening.